Warm welcome to Season 3, Episode 11 of ARBinBRIEF, a practical video on handpicked arbitration issues. My name is Winnie Ma. I am part of the ARBinBRIEF team and practice international arbitration from Australia with the arbitration chambers in Singapore. I'll be moderating today's episode featuring Sherlin Tung, partner at Withers Worldwide in Hong Kong, and Earl Rivera-Dolera, partner at Frasers Law Company in Vietnam. Both are well equipped to address today's topic of conquering the battlefield, how to build an international arbitration practice from scratch. So to both speakers, and maybe I should start with Earl, how do you build a team from scratch when building an international arbitration practice?
I would say not exactly from scratch or, exactly, zero plan or zero clientele. And I was lucky enough to be banking on almost 30 years of the firm's practice in Vietnam and its expertise on Vietnamese law. But of course, we also did not start on a level like you would have expected from an international law firm, a law firm that's part of the Global Arbitration Review top 30 law firms in arbitration practice. But like almost all full-service law firms within the region, most client instructions, I started with client instructions coming from internal referrals. From our corporate practice, energy practice, TMT practice areas, and contracts that had gone awry from those practice areas. So that's how we started. And from then on, we built our reputation in the market, and we grew the practice to further attract clients who may not come from our corporate practice areas or with no engagement from our firm before. And that's when we know that clients would now see us as disputes resolution specialists as well.
Great, thank you. Sherlin, how did you build your team?
I think maybe I should do a caveat, because when we say build a team from scratch, it kind of gives the impression that Withers did not have a commercial disputes or arbitration practice, which is not the case. We have a very strong international disputes, arbitration, and litigation practice worldwide. But what I mean when I say by scratch is because we actually didn't have a commercial litigation or arbitration practice in Hong Kong until about, I'd say, Q3 2018, which is even before I was hired. And when that was established, it was a commercial litigation practice. I was asked to come on board in around April of 2020 to then build the arbitration practice. And at that point, it was at scratch, just for us here in Hong Kong, and also technically Singapore. And when we build a team from scratch, I think what's important to note is, of course, you're going to need a team that has the capabilities technically, because that's how, and I'm sure everybody who is on this webinar or who will view the video will recognize that you can't actually have a good team unless you have a team that's actually good at what they do. But that's what you're really basically going to get from every single law firm, top law firm, leading law firm that you're going to hire to lead your dispute. You're going to be sure that you've got a team that has the technical qualifications, the language qualifications, etc. But what's different when you're building a team from scratch, basically in a situation where you're trying to build up from nothing, you need a team that's willing to do it. You need a team that's willing to kind of take on that challenge and take on the strategies and the different technical abilities needed in order to build that practice. Because trust me, when I was at my former firms, former institutions, etc., it was so nice already having established corporate practices, etc., that would happily refer cases to you on a regular basis. That is definitely what all of us achieve, I think, or wish to achieve in this field. But when you're really building up a brand new practice, your corporate team might not be ready to refer over to you because they're not too sure, one, what arbitration is, because there's never been one in the first place, or two, they might not do it just because they don't know how your team is. So how do you build a team from scratch? You need a team that's technically capable and able to do it, but also willing to go through all of the obstacles, all of the challenges. The team has to be able to know how to utilize their BD skills and go out to not only new clients, but also to internal teams that have never understood what international arbitration is and why they should refer their clients over to you rather than either settle the matter or, sadly, it's happened, just resolve the case in court, which they shouldn't if there's an arbitration agreement.
So it's never easy, is it, whether you are building from scratch or whether you're trying to retraining and restructuring everything. Now, the second question is for Earl only. How do we build a client base, especially in a non-traditional jurisdiction such as Vietnam or even the Philippines, perhaps?
For sure. So yeah, as a non-traditional jurisdiction, I would define it as something that's not a hub, that's not considered as a hub for arbitration practice, as compared as opposed to, let's say, Singapore or Hong Kong. What we did from the very start is, for me to be active in writing, in promoting, in speaking in conferences in Vietnam and outside Vietnam, and to change mindsets. From early on, I was very active in holding trainings, holding seminars, holding conferences, even organized by our firm, to change mindsets on the ground. For Vietnamese practitioners, for our foreign investors coming into Vietnam, and to see us as Vietnam-based law firm who do not only do arbitrations with Vietnam-based arbitration centers. And that's one thing that we needed to do from the very start, from the very get-go, that Vietnam-based law firms can do arbitrations in Singapore, can do arbitrations anywhere, just like Hong Kong-based arbitration specialists could do arbitrations in Singapore. Latin America, South America arbitration practices could do arbitrations in Singapore, in London, wherever the contract would lead us. So that's one thing that we needed to do from the get-go, change mindsets at the start. And one thing that we also wanted, that we promoted from the start, is our arbitration-related court proceedings that we are able to do. That's one major source of our client instructions, to do interim measures, enforcement procedures in Vietnamese courts. While as a foreign law firm, we do not have right of audience in the courts of Vietnam. But most of our clients who would ask us to do interim measures or apply for interim measures, apply for petitions for recognition and enforcement of arbitral awards, they would usually instruct us as coordinating counsel, and then we instruct a local barrister to be authorized and appear in court for these arbitration-related court procedures. Clients with no Vietnam component at all have recently, of late, have instructed us or have sought our advice, and that's when we know that, okay, I think our reputation is starting to be built up, that we do not only do Vietnam-related arbitrations, but from the get-go we needed to change mindsets.
But it was certainly an eye-opening experience working in an arbitration hub and then moving on to a non-traditional jurisdiction. Now, the next question is for you, Sherlin. What challenges have you encountered within the firm, the team, the community, or even with clients? And how can we overcome those challenges?
Should learn to prepare more, because I noticed that I alluded to a lot of this in my last answer, but I'm happy to actually reiterate and elaborate again. Some of the challenges you face within a firm, in particular for a practice that is new for not the firm itself, but the area, the region, educating the rest of the practice groups of what is international arbitration. One of the biggest pet peeves that I've had since my days with 𝗔𝗥𝗕𝗙 or even at the ICC is that a number of litigation lawyers always like to say that arbitration is just litigation. It's the same thing, but it's really not. And the whole point of arbitration, and I'm sure everyone who watches this video knows because you are all arbitration experts or are interested in it, we are a different form of dispute resolution method, different method to resolve disputes. We believe ourselves to be a bit more amicable in a way, and it's not as litigious as you can get with courts. There are a number of other factors, obviously, that are beneficial to arbitration. We know this very well, but our other practice groups, in particular those who aren't familiar with what arbitration is, they don't. And that's why oftentimes you see these practice groups just kind of defaulting to court litigation, which in fact in the end, it ends up being the wrong advice for the client, because there are situations such as international business transactions, which actually benefit much more from an arbitration than it does from a litigation. Now, other types of challenges are clients. So whether our clients are of a different base, generally speaking, than what I've been used to in the past, it doesn't mean that they don't have disputes, and it doesn't mean that they don't have the same issues and problems that big companies do. But it does mean that oftentimes, because of the type of work that they usually come to Withers with, they're not necessarily experienced when it comes to the idea of international arbitration. Or on the other hand, they are very well established, mature, and professional companies that understand what arbitration is, but they've never associated arbitration with Withers, at least not the Asia offices. And that's a challenge that we've had to face, because my team is comprised of very highly skilled professional, and just to be honest, they're amazing. The team is amazing. They're great technically. They're great to work with, except when they argue with me, but that's okay, because I understand that they argue because they also have their own opinions and I'm not always right. But it's a great team. How do you sell it to your clients who have actually never heard of Withers having an arbitration practice? And this is what we faced 4 years ago. 4 years later, I'm very happy to say that we've clearly started to kind of break down those obstacles. But those are the challenges that you will see, not within your own firm, but also with the clientele. Also, when I actually brought my clients over to Withers, there was a little bit of a negotiation or reassurance that Withers will be able to offer the same type of services and work. Our team remains the same, even though we don't necessarily have that reputation. And that's what it is. That's why it's kind of conquering the battlefield, because you're embarking on something completely new. Now, if I don't know, Winnie, you can cut me off when I lose track of time. But one last thing I would like to mention with respect to challenges within the community. We are all very familiar that international arbitration, as big as it might seem, we really are just one small family. One bad incident can easily travel all around, because people gossip, people talk. And all it takes is just one negative thing to say, which may 99% of the time is not true. It just gets exacerbated. So one of the main conflicts from within the community that I think most people have to face, in particular those trying to establish, new practice groups or new practices, is, the reputational front. You might hear one or two bad things. And I mean, you hear this from an institution. When you're appointed as an arbitrator, you always try to make sure you don't do anything negative, because guess what? If something negative comes up, that arbitration institution remembers. Well, it's kind of the same within the community with your peers. And I think one thing to say is, kind of take everything with an open mind and actually speak to the individuals and people that are involved to make a judgment before you actually make a judgment, because everyone has their own side.
Thank you, Sherlin. I think I'll still ask the last question, but I'm going to confine you to one sentence in answering that question, because this question will probably resonate with everyone. What makes tackling those challenges worthwhile? Why do what you do rather than be part of something more conventional or stable? Earl?
Then I would loop back with what Sherlin mentioned earlier. Clients could be a challenge, but clients could also be, the reason why tackling such challenges could be worthwhile, especially the satisfied clients. I wouldn't attempt to say that I have 100% satisfied clients, but that percentage of satisfied clients make tackling all these challenges in practicing arbitration in a non-traditional jurisdiction quite worthwhile. How we were able to attract them rather than them going to, let's say, a Singapore law firm or Hong Kong law firm or other major hubs of arbitration. And then, having their good feedback of the work that we do, that makes all the challenges worthwhile, I would say. Even clients who would have engaged us even without any, their cases without any Vietnam component, but because maybe, they're from the Philippines, where I am from, or they were contacts of mine when I was still based off Singapore for 11 years, and they would rather have us, my team, conduct the arbitrations because of the experience that they've had when I was managing their cases when I was still in Singapore. Then, that makes starting from scratch, so to speak, all worthwhile. Would I rather do or be part of something more conventional or stable? I wouldn't say no. I wouldn't say just straight I wouldn't go that far or I wouldn't want something that's more conventional or more stable. But I think we're at that level going into that, being part of the more conventional already or being part of the mainstream. I wouldn't say we would make it a top 30 of global arbitration review, and all that. But from the perspective of foreign investors coming into Vietnam, the reputation that we've built, I think, is going now into the more conventional law firm with an arbitration or disputes resolution focused practice.
And thank you, Earl. Sherlin, I think we can leave yours to the Q&A session because that will entice everyone to join in. So thank you so much to Shel and Earl for those incredibly insightful discussions. We would like to thank our partner organizations, ARBINBRIEF and the Lagos Chamber of Commerce International Arbitration Center. We are also grateful to the many organizations that support the marketing of our series. For those of you watching on YouTube, our video ends here. To see further ARBINBRIEF videos, please follow us on LinkedIn and subscribe to our channel on YouTube. We would love to hear your feedback. And you can register for our next episode on www.arbinbrief.com. Thank you for joining us.